So here we stand, seemingly at the end of a scandalous journey in search of justice. But what is the turning point that will finally shatter the injustice deadlock that has so successfully rendered this case a legal disgrace? For some, this ending could be catastrophic, but that will all now be dependent on legal industry acceptance of accountability. Regular viewers of this channel will know that many videos have already been devoted to exposing the unlawful conduct underlying the 2012 Brampton civil case, Edwards versus Morneau Shepell. Despite conclusive evidence exposing case illegalities, the Ontario legal industry has ignored the implications. This means that incontestable proof now exists showing that legal authorities and lawyers have repeatedly failed to uphold mandatory standards imposed by law and governing legal codes, despite swearing an oath to uphold them. And this failure is not isolated. To even initiate civil action, a court-mandated filing fee was required. With payment comes a clear obligation: professional standards must be upheld. Payment is not merely a fee, it establishes a binding expectation that the justice system will meet its professional, legal, and ethical standards competently. When those standards are not upheld, it represents a failure to deliver the very service that was paid for. In plain terms, despite those paid obligations, mandatory legal codes conclusively establish that in the way it has been treated, this case is unlawful. Yet many within Ontario's legal industry remain on record refusing to enforce the very law they are, again, sworn to uphold. The result has been the direct and foreseeable cost imposed on a litigant forced into self-representation after confirmed malpractice created the very need for the litigation in the first place. The Edwards videos leave nothing to the imagination, and to say they have brought Ontario's legal industry into scandalous disrepute would be an understatement. Yet the Ontario Law Society appears unfazed by the public fallout, maintaining a posture that is fundamentally at odds with its own rules of professional conduct, which impose a clear, mandatory duty on licensees to report serious misconduct, particularly misconduct that raises substantial questions about a colleague's honesty and trustworthiness. Put plainly, the profession is required to protect the public and uphold the honor of the bar by confronting behavior that can harm clients, mislead the courts, and corrode the integrity of the system. The Edwards case, therefore, creates the stark impression of a regulator reluctant to enforce its own standards, treating a mandatory duty as though it were optional, a perception many find breathtaking in its implications for public confidence. Unable to be recognized as anything else, an abomination, the Ontario Law Society has been fully put on notice that this case injustice stems from lawyer misconduct by Shepell lawyers Roslynn Kogan and Pamela Miehls. Yet, even with conclusive evidence, the rules themselves, and a chorus of practicing lawyers on public record confirming the code breaches, the Law Society still refuses to acknowledge the lawyer misconduct, and the professional fallout is staggering. By taking its stance, the Law Society is effectively throwing a host of other lawyers under the bus, implying that it is they, and not the regulator, who are misleading the public about what is, and what is not, misconduct. If left unaddressed, one conclusion becomes inescapable. In defending the conduct of the lawyers Kogan and Miehls, the Law Society is effectively asserting that numerous other Canadian lawyers are publicly spreading disinformation about the rules and their interpretation. Intolerable, such a legal schism is wholly unacceptable. It fractures the integrity of the profession and exposes countless lawyers to claims of misleading the public. The position is incontrovertible. The Law Society cannot lawfully defend conduct the legal code defines as misconduct without undermining its own integrity. As a matter of record, Shepell's factum, a fabricated document, has been legally confirmed an improper pleading in breach of mandatory procedural rules. Unavoidable, to defend it is to act in bad faith and to betray the Law Society's mandate. Confronted with institutional hypocrisy and, on any reasonable view, fraud, the Edwards case demands legal intervention to determine where the breach of duty lies and to assign liability for the deliberate obfuscation of the rules deployed to shield misconduct already on record. The Ontario Law Society's reckless abuse of authority has brought the profession into disrepute. Continuing to act against its own code while refusing to correct the breach is not legally defensible. After years of complaints and sustained public evidence, there remains no meaningful response to an injustice the legal code itself defines as unacceptable. Ontario's legal industry now stands on record as ignoring its own rules, a failure the public can only view as a profound legal disgrace. Before moving on, consider the magnitude of this refusal. The industry entrusted to uphold the law and enforce its own code is declining to do so on the record, despite a breach that is indefensible and that is a staggering breach of trust, exposing how deeply entrenched the problem becomes when the public challenges the legal establishment. Edwards has pursued this matter exhaustively, with independent investigators finding his allegations legally compelling. Yet his whistleblowing has been met with institutional silence without consequence. He argues this is not oversight, but deliberate obstruction, designed to shield the misconduct from scrutiny and keep it beyond public accountability. Despite credible wrongdoing being ignored by legal authorities, this case represents a clear injustice, one that actively shields lawyer misconduct from accountability. And this raises a fundamental legal question. If the law will not act on proven rule breaches from within its own ranks, how can it credibly demand compliance from the public? In the Edwards case, we witness firsthand what happens when the alarm is raised to one person in authority and how their negative inaction becomes a precedent, triggering off an outrageous chain reaction of professional negligence that obstructs and prevents justice being served. Law without justice. The public has long assumed the legal industry exists to deliver fair justice. However, increasingly, that is not what it appears to prioritize. What is now on display is something else. Winning for the client is treated as the overriding objective, even where there is no legitimate legal justification. And this, for those forced to represent themselves, can quickly become a disaster just waiting to happen. So, for the benefit of new visitors to this channel, here's what the Edwards case issues are and why, as a matter of legal rules and basic legal integrity, the matter must be reopened and struck out as the only reasonable remedy consistent with the law. And let's make no mistake, this must be done. Otherwise, the system is left effectively upholding and perpetuating an unlawful precedent. In 2010, Morneau Shepell guidance counselor Cathryn Heyman, shielded by confidentiality, made defamatory statements about Edwards, who at the time was an unwitting third party to her counseling. Her statements were unsupported, professionally indefensible, and legally actionable. Heyman's statements caused catastrophic harm. They destroyed Edwards' family and placed his life at risk on 2 occasions. In counseling terms, her conduct fell below even the most rudimentary professional standards expected of a Canadian counselor, providing clear grounds for legal accountability, particularly where foreseeable risk to human life was involved. At that point, the situation was straightforward. However, that clarity was destroyed the moment Morneau Shepell's senior in-house lawyer, Roslynn Kogan, entered the equation. From the very start, it was glaringly obvious that once Roslynn Kogan got involved, she was not there to uphold the law, she was there to undermine it. Instead of ensuring justice, she acted in direct contradiction to the legal code that demands lawyers facilitate fair proceedings. In short, she turned what should have been a pursuit of truth into an outright obstruction of justice. The first issue was fundamental: the deliberate obstruction of litigation. Roslynn Kogan refused to acknowledge that Cathryn Heyman was even employed by Morneau Shepell, yet simultaneously insisted that any claim be brought against Shepell rather than Heyman personally. This was not mere evasion, it was obstruction. The position created an impossible condition, denying Heyman's employment while insisting proceedings target the employer. By concealing Heyman's contact information, the defense rendered direct service impossible and blocked accountability at the outset. Forcing Edwards to sue Shepell turned justice into a mockery. How can you prosecute a party disconnected from the actual wrong? By diverting the target onto Shepell, Roslynn Kogan turned accountability into a nonsensical shell game, deliberately redirecting responsibility away from the individual whose actions caused the harm. To give viewers a clear synopsis of the court events, having been forced into self-representation by the fallout from Cathryn Heyman's malpractice, Edwards presented to the court verified documented facts that satisfied the legal test for libel. On his documented evidence alone, the case should have been won. Instead, Justice Thomas A. Bealby at the Brampton court sided with Morneau Shepell's counsel in court, Pamela Miehls, from the Toronto law firm Aird and Berlis. A decision that disregarded the established facts and marked a decisive departure from the law governing libel. So, amidst an already controversial judgment, what was the strength of Pamela Miehls' legal argument to the court? Factually, and by legal definition, it was not an argument addressing the litigation at all. The required legal test wasn't met, the core facts weren't overturned, and yet the court ruled in Shepell's favor anyway. In other words, it wasn't the argument that won the day, it was a decision reached without applying the law. At this point, one might assume the outcome turned on the credibility of Cathryn Heyman's statements to the court, except it could not, because Heyman never attended court. She gave no evidence, filed no mitigating statement, and is not on record disputing any claim made against her by Edwards. More critically, she is not on record endorsing or supporting any assertion made on her behalf in Shepell's factum. Indeed, Shepell's factum didn't even name Cathryn Heyman as someone to be defended, recognized, considered, or even to be taken into account. In reality, Heyman was entirely absent from her own defense. Incredibly, Shepell's factum simply sidestepped Cathryn Heyman, functionally making it impossible to test, scrutinize, or attach accountability to the very conduct and person at the heart of the case. It was as though the central figure of the harm didn't exist, allowing the actual wrongdoing to circumnavigate all liability. For all legal intents and purposes, Cathryn Heyman took no part in the proceedings whatsoever, yet the court nonetheless ruled as though she had. And just how profoundly wrong that was becomes glaringly obvious by what follows. What elevates this case into a legal industry scandal is its unavoidable implication revealed by a subsequent private investigation that found that the narrative underpinning Morneau Shepell's factum was entirely fabricated. This was not a mishap, it was a polished submission prepared by experienced corporate lawyers, and the conclusion is unavoidable. Shepell's factum was not advocacy, it was a cover-up. 19 pages of pure fiction that successfully obstructed justice. And it is the conduct of Shepell's lawyers that sits at the very core of this scandal. The Law Society of Ontario's rules of professional conduct are clear. Under Rule 5.1-2, it states, when acting as an advocate, a lawyer shall not knowingly mislead the tribunal or offer evidence that the lawyer knows to be false. And that duty doesn't end the moment the words are filed. If anything false or misleading has been put before the court, it must be corrected because legal statements are required to be supportable. When a lawyer refuses to correct the record, their inaction becomes just another part of their deception, and the fallout is unavoidable. The litigation itself becomes an unsupportable nonsense. As if to emphasize this point, in his endorsement, Justice Bealby stated that it would have been a simple matter for Edwards to have Heyman attend court. This was clearly an assumption, one based on the impression created by Shepell's factum that Heyman was in fact a Canadian counsellor. But in reality, investigators later confirmed that Cathryn Heyman was based in Austin, Texas. Thus, there was nothing simple about securing her attendance. It would have required a formal extradition order. This error exposes a critical flaw in the court's reasoning. The judge's focus shifted away from a fundamental point. The onus was in fact on Shepell to produce Heyman as part of her own defense. Instead, that burden was improperly placed on Edwards. The result is a judgment that is fundamentally inadequate and fails to properly address the case. So now understanding the straightforward legal parameters, what are we to make of this? Justice Bealby raised this as an issue before allowing the hearing to begin. He was concerned that Shepell's factum did not identify Cathryn Heyman as a defendant to be defended. That concern wasn't minor, it went to the basic integrity of what the court was being asked to decide, and against whom. But Shepell's lawyer, Pamela Miehls, quickly neutralized his concern by assuring him that, even though Heyman wasn't named, every statement in Shepell's factum was nonetheless pertinent to Cathryn Heyman. Justice Bealby accepted her assurance without challenge. However, as can now be identified from that moment on, he was being professionally manipulated by active misdirection. Unbeknown to Edwards at the time, a later private investigation revealed that Shepell's case, as legally constructed, was, in fact, entirely fabricated and, contrary to Pamela Miehls' assurance to the judge, nothing in Shepell's factum was pertinent to Cathryn Heyman. The evidence is conclusive on this first issue. Pamela Miehls misled the court directly. That alone is sufficient to vitiate the proceeding, and there should be no need for further revelations. However, for completeness, let's identify how this legal defense amounted to outright fraud. Unable to dispute their breach of duty of candor and compounding their initial misconduct, Shepell lawyers escalated the deception by concealing the on-point authority they were legally required to disclose to the court. Presented in a way that made Shepell's defense appear legally plausible, its factum cited the member ethics of the Ontario Association of Consultants, Counsellors, Psychometrists, and Psychotherapists, the OACC-PP for short. By relying on OACC-PP standards, it created the impression that Cathryn Heyman was a member of a Canadian licensing body. It also gave the appearance that Shepell had fulfilled its obligation to place relevant on-point professional authority before the court. Except, as the private investigation later revealed, the OACC-PP was not Cathryn Heyman's authentic licensing authority at all, and it was, in fact, the Texas State Board, based in Austin, Texas.
You don't know anything about me.
I know almost everything about you.
This authority substitution left the court relying on yet more disinformation. And if anyone doubts how improper it was, the OACC-PP itself has since confirmed that its member ethics can only be invoked in relation to the conduct of its members, and Cathryn Heyman was not, and never had been, a member. So this licensing authority substitution was misleading and, being legally inadmissible, it had no place being put before the court. Indeed indisputable, this concealment of the on-point licensing authority cannot reasonably be dismissed as a mistake. It must be the case if, as Pamela Miehls confirmed, she was acting on Cathryn Heyman's instructions. One question becomes unavoidable. How could Heyman have misidentified her U.S. licensing authority as a Canadian one? Or was this misidentification deliberately adopted to conceal? Morneau Shepell employed counselors not licensed to practice in Canada? Beyond revealing that Cathryn Heyman operated in a country where she was not licensed to practice, this authority substitution revelation underscores something even more serious. Shepell's lawyer Pamela Miehls gave assurances to the court that were not merely misleading, they amounted to an outright false representation. And that false representation could only have influenced the judge's approach, steering the outcome on a foundation that was never true. At this point, we can indisputably identify that Shepell's factum was both frivolous and vexatious, and, as such, an abuse of the court's process. It should also be noted that the legal system rejects claims made in bad faith. But the consequences of this deception go even further. After the Brampton court case, the Texas State Board conducted its own ethical inquiry and determined, in direct conflict with Justice Bilby's misguided decision, it confirmed Cathryn Heyman had indeed violated Texas State Board counseling ethics. So, we are left with a Brampton court decision that fails to uphold governing legislation and established legal and ethical standards which, if had been candidly presented before the court, would have made it impossible for the court to support Shepell's case. Not an unreasonable conclusion, this makes the legal paralysis in addressing this injustice all the more disgraceful. So now, supported by authentic discovery and having reached a point where the legal code itself indicates that Shepell's case factum does not align with legal standards or obligations, the pressing question remains, why is no one, in an industry that relies on integrity, willing to confront the severity of this injustice? One reason is most apparent. A global consensus. Over decades, the law has been steadily eaten away by lawyers advancing deceptive, nonsensical arguments and, ruinously, getting away with it. When lawyers cross the ethical line, there is nothing superficial about the harm that can follow. Abuse of professional privilege can devastate lives. When an officer of the court abandons honesty, it is not a minor breach or a technical violation. It strikes at the integrity of the process itself. We must not forget, a courtroom functions only because officers of the court are bound to candor and fairness. Once truth is deliberately abandoned, the process itself is contaminated and justice is compromised at its core. This should not be interpreted as a technical lapse or a harmless tactic. It is a profound betrayal of the public trust that legitimizes legal privilege in the first place. In short, lawyer deception is unacceptable because it undermines the rule of law itself, and when legal institutions refuse to correct it, they inescapably become complicit in the system's destruction. Impunity by design. Every day, lawyers wield enormous power over people's lives, and too often that power is exercised without consequence. Decisions made in courtrooms and legal offices can ruin reputations, destroy livelihoods, and devastate families. Yet within the legal industry, this harm is routinely dismissed as an acceptable byproduct of aggressive representation. That acceptance is itself a profound injustice. When the system tolerates the routine destruction of lives and treats it as collateral damage in the pursuit of legal victories, if not controlled, it automatically becomes a danger to society. And here's what Roslynn Kogan and Pamela Miehls appear to have forgotten. Legal privilege is conditional. It exists only to protect statements made in proper accordance with legal code. The moment a lawyer steps outside that framework, by breaching the rules, misleading, or relying on misrepresentation, the claim to privilege loses its legitimacy because the privilege is justified only by compliance. So, in the absence of compliance, professional privilege is automatically forfeited. But even this fundamental legal reality was sidestepped when the case reached appeal in Toronto. Edwards raised what should have ended the matter on the spot. Shepell's case was entirely fabricated. Yet Miehls' argument casually dismissed the legal significance of Shepell's factum being an improper pleading, asserting that it contained no evidence, only statements. Miehls' assertion does not resolve the impropriety, it sharpens it. To describe a factum as only statements defeats the document's very purpose. A factum exists to present supported facts and legal argument, not unsupportable assertions. The rules prohibit an unsubstantiated factum misleading the court. Suppressing material facts and maintaining improper pleadings, a case built on assertions untethered from evidence violates ethical duties outright. Simply put, once a pleading is known to be unsupported, misleading, or fabricated, it must be corrected or withdrawn, not defended with semantics. As the Supreme Court in R. v. Bjelland affirmed, judges are the gatekeepers of fairness. If there is any doubt about the integrity of submissions, the court has a duty to inquire and act, upholding the integrity of the process. But astonishingly, Pamela Miehls' argument was treated as sufficient to deny the appeal. And so, once again, an illegal case judgment in the first place was left standing, this time by another Ontario court, despite being irreconcilable with law and legal code. Just so the viewer doesn't feel like they're losing their grip on reality, a factum isn't meant to be a bundle of throwaway statements. Procedurally, candor-driven, it's supposed to set out a concise summary of the supportable relevant facts. When a lawyer in court assures a judge that everything is pertinent and grounded in fact, the expectation is that these claims meet the legal standard. This principle is explicitly addressed in the legal rules. Under Chapter 5, Relationship to the Administration of Justice, it states, when acting as an advocate, a lawyer shall not knowingly assert as true a fact when its truth cannot reasonably be supported by the evidence, or as a matter of which notice may be taken by the tribunal. Not abstract, the rule makes it exactly clear the conduct witnessed is prohibited. What follows is its application. If a lawyer later admits that a factum contained no evidence, only assertions, it is a direct breach of what the court demands. Courts don't rely on assertions. Legal arguments require verifiable facts. A factum must be substance, not empty lawyer rhetoric, and this legal position captures the inescapable difficulty that arises once confidence in legal representations is materially shaken. Every subsequent statement is viewed through a lens of doubt, and the risk of concealed truth becomes a central concern. When perceived misconduct appears to go unaddressed, the situation evolves into a test of whether institutional self-preservation is beginning to outrank the obligation to correct the record. Something else must be considered. the uncomfortable possibility that the system is structurally disincentivized from policing its own. Challenging a colleague carries professional, reputational, and practical risk, while silence is perceived as safer, rewarded by convenience, collegial loyalty, and institutional inertia. Another issue that frustrates victims of injustice. When legal code is applied selectively to conceal lawyer misconduct, it further exacerbates public trust. The Edwards case conclusively identifies that here in Ontario, legal code rules are not rigorously upheld against selective lawyers who break them, showing that the Law Society has its favorites. Having to be a factual observation, when enforcement becomes optional, lawyer misconduct is effectively pardoned in practice, and civil litigation becomes not only unreasonable but entirely unsafe. For civil litigants seeking justice who get brickwalled by the Law Society, you normally turn to every other authority meant to enforce integrity, but when every single one ignores its duty, you're no longer dealing with a process at all. You're facing a wall of complicity. It isn't just a failure of oversight, it's a system shielding its own, leaving the public with nowhere to turn, and that becomes a serious injustice in itself. Especially when the harm is severe and the consequences aren't something a person can simply absorb or forgive. Through deliberate legal inaction, the Edwards case was drawn into years of injustice despite him providing an overwhelming volume of verified evidence to a vast number of professional parties. Yet, despite all the investigation and recipients, no one took action. With legal code and established law identifying conduct amounting to criminal obstruction of justice, Peel Regional Police Chief Constable Jennifer Evans was contacted. She replied that it was a matter for the Brampton court to resolve, not the police. Over time, no fewer than 4 justices of the peace in Brampton then attempted to put the matter back before the court to address what they could see was an unsupportable defense document, but it was all to no avail. On one occasion, the paperwork was said by the court to have been lost. On another occasion, astonishingly, a judge announced in open court, in front of a courtroom full of people, that he didn't have time to deal with the matter. Completely unsurprising given the excessive delays dealing with the legal industry, on another occasion, Edwards was told he was out of time to have the issue addressed, but this is confirmed by Canadian Supreme Court precedent not to be the case. Before moving on, let's just clarify this situation outright so we can understand what so many legal professionals can be shown to have been ignoring. Under procedural integrity and abuse of process, the Supreme Court of Canada has emphasized that the justice system's integrity is paramount. Failing to address unethical conduct, even in time-barred cases, constitutes an abuse of process and allows the legal system to be used for fraudulent purposes. Inherent jurisdiction of courts. Courts have the inherent authority to address conduct that undermines justice, as highlighted in R. v. Reagan, 2002. This extends beyond individual cases to systemic concerns about unethical practices. Time-barred cases and misconduct. Statutory limitation periods are procedural safeguards meant to protect against stale claims. However, they do not absolve unethical conduct or fraud. Courts maintain the authority to address such misconduct even in time-barred cases. Fraudulent conduct as an exception. Fraudulent misrepresentation and deceit are recognized exceptions under the Limitations Act, 2002. Courts retain discretion to examine fraud when it undermines the administration of justice, as affirmed by the Ontario Court of Appeal in Agwini v. Galleon Solid Waste Material Incorporated, 1998. This underscores the principle that illegal and unethical conduct, particularly fraud, has no time limits when it affects the integrity of the legal system. So with fraud able to be identified in this case, it is clearly never going to be out of time to be addressed. But getting back to the illegal farce. Then, on yet another occasion, Crown prosecution stated that Edwards did not have as much credibility as Morneau Shepell's owner, Bill Morneau, who, at the time, was Canada's Minister of Finance. Serving as a complete distraction, quite apart from the fact that Morneau's position should have had no legal bearing on evidence of fraudulent lawyer misconduct, the irony soon became unavoidable. In court, the Brampton Crown prosecution portrayed Bill Morneau as the very pinnacle of credibility. Yet not long after, Morneau the Credible was caught in a scandal that forced him to resign from government and, of all things, for another non-disclosure violation.
Canada's MPs, by law, by rule, have to disclose all of their assets. That's been a rule, in fact, in this country for more than a decade. Well, CBC News has learned that one of the highest profile members of Prime Minister Trudeau's cabinet, the finance minister, Bill Morneau, did not reveal everything he owns. Nick Gamache has those details from Ottawa.
CBC News has learned that the finance minister waited 2 years to disclose to the ethics commissioner that
an unavoidable observation, with the Morneau organization turning non-disclosure into something of an art form. The Brampton Crown prosecutor, who so readily favored Morneau over Edwards, may wish to reconsider the wisdom of her demeaning presumptive reasoning over verified facts and, in future, safeguard legitimate public litigation from baseless personal assumptions that obstruct cases that have genuine legal merit.
This is how it ends. The finance minister resigns as the government plots an economic recovery from a pandemic.
I'll be stepping down as finance minister and as member of parliament for Toronto Centre.
The legal code is not equivocal, yet the Ontario Law Society appears unwilling to act when it is visibly violated. Why? Could it be, as suggested by the apparent bias shown in the Brampton court, that Bill Morneau's wealth creates for him an illusion of integrity? This is precisely the public perception, and it points to an unacceptable two-tier system of justice. Hard to believe after all we've seen, but the underlying principle of our courts is that the legal process exists to resolve genuine disputes, not to waste public resources or to be abused as a weapon. But the Brampton court has shown itself to be in a league of its own when inflicting injustice trauma. Spending years writing letters, compiling files, and repeatedly trying to confront an extraordinary level of legal negligence takes immense resilience, and many people simply fall by the wayside, mentally exhausted by the professional apathy and the sheer endurance required to carry on. But impossible to conclude otherwise, the Brampton court has gone to great lengths to block Edwards' complaint from being addressed, but in doing so, it has now placed itself in a direct and bizarre, untenable contradiction. King Charles has issued an official statement concerning a member of his own family, affirming that the law must take its course. Yet the Brampton court's refusal to address the verified illegalities in the Edwards complaint does precisely the opposite. So egregiously, the court's inaction has in fact actively prevented the law from taking its course. With Crown officials on record at the Brampton court acting in direct conflict with the principles publicly affirmed by King Charles, the court's obstruction of justice inevitably calls into serious question the court's legitimacy in displaying the Crown's royal crest, and particularly when that symbol is so widely understood by the public to represent justice. With all that has taken place, the extent to which Edwards has been successfully blocked exposes a hard truth about Ontario's professional class. Beneath the surface, though few would want to admit it, integrity is now conspicuously lacking across the board. The list of high-profile professionals who have turned their backs, choosing to enable unlawful conduct in this case, and to place lawyer misconduct above the civil rights of an ordinary person runs into the hundreds. But a handful of notable names show, unmistakably, exactly why our legal industry needs extensive reform. As the first port of call, the Ontario Law Society, through its Mr. Cass, misrepresented the situation. When faced with clear misconduct, the Society failed to uphold its own legal code, creating a damaging illusion that set a destructive precedent. As a result, others looking for guidance trusted the Law Society's stance, assuming it reflected the legal code when, in fact, it did not. In reality, the regulator's failure to enforce its own standards misled professionals into doubting the legitimacy of Edwards' complaint rather than the legal adequacy of the regulator's response. Pamela Miehls' firm, Aird and Berlis in Toronto. A total of 220 Aird and Berlis partners were individually canvassed and informed of Pamela Miehls' fabricated submission to the Brampton court. In due course, reply was received stating that Aird and Berlis partners would be standing behind the court judgment. In other words, 220 Aird and Berlis lawyers have chosen to stand behind a judgment despite being put on notice of allegations of fabricated statements. So, Despite the legal code's clear demand for accuracy and candor, Aird and Berlis have chosen silence over accountability, standing behind a judgment that legal code itself does not support. Ontario Attorneys General Caroline Mulroney and Doug Downey were both made aware of the issues in this case, yet, despite the weight of their offices, each declined to intervene. Add to this, Canada's Attorney General, Arif Virani, also chose not to become involved. Taken together, this pattern of institutional distance raises serious questions about who, if anyone, is prepared to act when alleged misconduct falls between jurisdictions and formal responsibility is repeatedly deferred. Prime Minister Mark Carney has also been approached, and clearly in his own words, he fully understands the seriousness of the issue.
When the rules no longer protect you, you must protect yourself.
Sadly, the Prime Minister's office has also stated it cannot get involved, despite the serious implications this raises for the integrity of Ontario law and the risk of alienating voters. The difficulty with his response is that when those at the top decline to act on credible allegations of misconduct, inaction can appear indistinguishable from tacit acceptance, a perception that risks provoking a public reaction no justice system can afford to ignore. No miscarriage of justice happens in isolation, but showing breathtaking duplicity, the case judge, too, had a duty, and he has also failed it. At first, like Edwards, Justice Bealby could not have known that Pamela Miehls' factum was fabricated because key information capable of conclusively establishing the merit of Edwards' litigation had been withheld at the outset by Roslynn Kogan. But the true test of duty lies in what happens when the truth emerges, and that is precisely where the failure begins. On 3 occasions, Edwards has tried to inform Justice Bealby that Shepell's lawyers have tenaciously held his position in criminal contempt by drawing him into proceedings, now able to be legally characterized as obstruction of justice. The last documents were delivered directly to him at the Brampton court. Yet, rather than a reply from him, Edwards received a letter from Justice E. Riet Simas. The letter advised Edwards to retain a lawyer or seek free legal advice, overlooking that he was already citing the legal code verbatim, supported by lawyers on public record expressing the same core position. The contradiction is unreasonable to ignore. If Edwards' complaint truly had no legal merit, why are 4 Brampton justices of the peace on record attempting to have the matter returned to court? If there were no substance, what explains their legal effort to reopen the case? And if that effort is resisted, what does that say about the fair process required that seemingly has eluded the Edwards case? The judge's suggestion is unhelpful in this respect. Edwards, based on legal advice, is relying on documented evidence that identifies a serious code breach. At the end of the day, to ensure fair litigation, the court is bound to uphold the legal code, which dictates what constitutes a proper pleading. Edwards maintains that Shepell's factum cited an authority that, he contends, should never have been cited in the first place because it was not legally applicable to the case. If that contention is borne out by the record, the Brampton court has a duty to address the risk of an unsafe precedent undermining and influencing future cases. Given the severity of the harm this case has inflicted, adherence to the law is not optional. It is essential to protect the integrity of the system. But adding insult to injury, Justice Simas also warned Edwards not to contact Justice Bealby or court staff again, threatening that any further communication would result in a court order. Impossible to be interpreted in any other way, this threat against a whistleblower is a clear attempt to silence disclosure, targeting the messenger instead of confronting the illegality being exposed. So to an extraordinary degree, we're left with this reality. Edwards' stance is grounded in professional codes and backed by numerous lawyers on public record. Yet the Brampton court appears more inclined to just erase the lawyer misconduct as if never taking place, and all at the direct expense of an ordinary citizen. In doing so, it effectively leaves Justice Bealby to carry the fallout, tolerating a situation where his authority has been treated with criminal contempt by lawyers, unchecked. And inevitably, that raises serious questions about the Brampton court's commitment to upholding legal integrity. Section 7 of the Canadian Charter of Rights and Freedoms guarantees life, liberty, and personal security, and as such, The public deserves fair and protective legal processes, not neglectful harm. Thus, the conclusion is clear. By doing nothing, each professional authority that ignored this verified injustice has effectively itself obstructed justice being served. This inaction isn't neutral. It has ensured this injustice continues, and that failure now demands full accountability. One unavoidable question is whether the financial weight and institutional reach surrounding Bill Morneau and his former company have made this story easier to sidestep than to confront. Morneau Shepell rebranded as LifeWorks in 2021, then was sold to TELUS on September 1, 2022 for a reported 2.3 billion Canadian dollars and was subsequently folded into TELUS Health. However, none of that new corporate repackaging addresses the underlying issue. Rebranding doesn't erase a legacy of unlawful or unethical conduct, it merely changes the label on the door. It must be accepted. If misconduct is left unexamined, it remains unanswered, and the risk of repetition remains. The point isn't the rebrand or the sale. It's the unresolved accountability that lingers regardless of the corporate facelift, and the danger of letting reputation and money do what law and ethics are supposed to prevent. A prime example is Morneau Shepell's own corporate ethics code. It prohibits the very conduct their guidance counselor engaged in. But in any organization where ethical values are not enforced, an ethics code becomes little more than a brochure to entice new clients, and wrongdoing simply carries on under a different name. And on this occasion, that name is TELUS Health. And just so we are clear about the extent of corporate corruption, Bill Morneau was fully aware of the unethical conduct that had taken place and still chose to do nothing. Despite the fact that the unethical conduct contradicted Morneau Shepell's own stated corporate ethics. Bill Morneau is now a corporate director at CIBC. Clearly, CIBC's wisdom in offering him the position, viewed in light of the verified evidence, must, with hindsight, leave something to be desired. But isn't it always the case? People with money constantly seem to find a way to avoid culpability. Absence of accountability. Victims traumatized by lawyer misconduct are entitled to accountability that corrects the wrong. Yet the Edwards case shows the structural danger when a self-governing legal profession refuses to enforce its own rules against its own members. That refusal operates as a de facto pardon for conduct the profession code classifies as professional misconduct. In this situation, the issue is no longer merely individual wrongdoing. It becomes an abuse of institutional power, because the public safeguards that justify legal privilege are being withheld. The only lawful way to overcome that abuse is to force the matter out of the closed disciplinary loop and into independent oversight and transparent review, so that the rule of law is applied externally and consistently rather than being selectively suspended behind professional immunity. But until that happens, how can the public overcome a self-governing profession that can effectively insulate itself from consequences? If you could just remind us again, Prime Minister, please.
When the rules no longer protect you, you must protect yourself.
We are no longer in an era where malfeasance can remain hidden.
There is a legal term that I like to use in instances like this: fuck around, find out.
The public is now active, relentless, and unafraid to speak truth to power. For 14 years, Ontario fake justice has created an entrenched legal impasse, preventing the Edwards case from obtaining justice. Through conduct that breaches its own rules, erodes public trust, and reflects sustained malfeasance, the Ontario legal industry has effectively taught the public not to play fair. Therefore, it should not be surprised when it is forced to reap what it has sown. Let's just remind ourselves.
When the rules no longer protect you, you must protect yourself.
Preempting this very reality conveyed by Prime Minister Mark Carney, to dismantle the imbalance once and for all, some members of the public and PIs have been investigating improper conduct by members of the legal industry. Their objective: to expose an industry that has long portrayed its members as above reproach, when, in fact, many are not. The inherent issue is fundamental to a harmonious society. Accountability cannot be selective. A profession is only as credible as its weakest link, and where integrity cannot be consistently assured, its authority to judge others is inevitably called into question, especially when those making the accusations may themselves be guilty of the same. The reckoning starts. On-the-ground activism against legal injustice has evolved into a global struggle against lawyers who abuse power, and the tactics used to confront perpetrators are becoming increasingly uncompromising. When every reasonable avenue for redress has been exhausted to no avail, escalation ceases to be a public choice and becomes the only realistic option. A shift from appeals and petitions to sustained organized pressure that compels institutional action through public accountability, and this is the inevitable consequence of a sustained refusal to confront wrongdoing. As a stark example, with so many U.S. lawyers being publicly convicted on criminal charges, America has shown how easily deeply unethical individuals can thrive with impunity inside the legal industry, until that is, they are caught up by those outside of it. Therefore, it is hardly surprising, second only to CEOs, the legal profession is often cited as attracting personalities with sociopathic traits. Given its standing within global society, and the possibility that it may harbor so many untrustworthy individuals, it is difficult to see any adequate solution other than the rigid, uncompromising enforcement of legal code to confront the potential extent of corruption within the industry. And Canada cannot be excluded from this reality. It has simply not had its extent of corruption brought to light yet. However, after years of watching investigations neutralized by lawyers exploiting institutional credibility to sway outcomes, some PIs have decided to take a stand and confront that credibility directly to restore balance. Recognizing a global pattern. Just as Bill Morneau's manufactured credibility was weaponized in the Brampton court to diminish Edwards' position, PIs have repeatedly seen the same tactic used to undermine their clients, where a lawyer's word is treated as sacrosanct, beyond question or scrutiny. This pattern is not isolated, and in fact, what began as an American initiative has led to a clear conclusion. Only a decisive shift can counter entrenched lawyer bias and break the system's automatic deference to lawyer credibility. In 2026, the world has ignited in widespread defiance of injustice, and the consequences for perpetrators are becoming life-changing and impossible to ignore. In some cases, ensuring that a message is heard has turned disputes into no-holds-barred confrontations, with the protest landscape evolving into a free-for-all, one that some American PIs have capitalized on to help level a legal playing field distorted by lawyer misconduct. But when dealing with imperious, unconscionable legal actors, convinced their misconduct will never be exposed, or that, if it is, it will be suppressed by a system intent on protecting itself, the question becomes unavoidable. What force could compel dishonorable lawyers to come clean?
We are anonymous. We do not worship celebrities. We do not excuse abuse just because it wears a suit and a flag pin. We do not pretend that the private behavior of powerful men is somehow separate from the way they wield power in public.
This is where the gloves-off approach comes into play. In today's legal climate, protecting liability over ethical resolution is commonplace, and many see it as the inevitable consequence of decades of law societies shielding wayward lawyer actions. Despite being shunned by some, including the Brampton court, whistleblowing has become a powerful force against unethical conduct. And now, in growing numbers, people are no longer staying silent.
The United States of America is in a world of hurt because the president of the United States is a convicted felon, a con man, and a world-class incompetent dipshit.
When individuals act immorally or institutions fail to put wrongs right, people are increasingly willing to set the record straight themselves, publicly, forcefully, and without regard for their reputations destroyed in the fallout. Once, disputes were handled with restraint, but no longer. Exposure has become leverage. Now, the personal damage to wrongdoers is treated as fair, with this harsher reality increasingly viewed as the only way to confront issues long suppressed by personal or systemic bias. In practice, many lawyers feel insulated from public retaliation, their professional status acting as a shield against consequences ordinary people would face. Add to this the public's understandable fear of crossing legal lines and risking charges themselves, which only reinforces the profession's protective barrier and leaves ordinary citizens with little practical leverage when formal accountability fails. The result is a stark dilemma. How do you challenge those protected by the legal industry without compromising your own legal safety? A conclusion the Ontario legal industry will not want to face, based on an American success strategy of fighting fire with fire. Some Canadian investigation activists are about to inadvertently implement a mirror image strategy of what Cathryn Heyman effectively did to Edwards, with the potential to inflicting equally destructive consequences, but this time on lawyers. And legal code points out the motivation factor. Not that the Ontario legal industry seems to be paying any attention to legal code, but let's just confirm a rule that makes clear: reputation is everything. Rule 2.122 states, a lawyer has a duty to uphold the standards and reputation of the legal profession, and the commentary to Rule 2.121 adds that dishonorable conduct in either private life or professional practice may reflect badly on the profession. A fundamental flaw. The problem for the legal industry is that this specific rule ignores basic human nature. Lawyers are not immune to human psychology. They carry the same flaws, pressures, and instincts as everyone else, and a system built on denying that reality is inherently unstable. It will break, and when it does, honor and professional standards are the first casualties. However, let's cut to the chase. For years, relentless private investigators and wronged victims have meticulously gathered damning evidence against dishonorable Ontario lawyers, awaiting the pivotal moment to expose misconduct so undeniable it demands action. But how, without going to an extreme, can lawyers ever become decisively discredited when, as the Edwards case shows, the legal industry can simply ignore formal complaints meant to hold lawyers accountable? Well, you have to admire the tenacity. But once again, America shows us the way forward here in spectacular fashion. A well-executed laser show can transform any space into a breathtaking, immersive environment that can captivate audiences, drawing attention to every detail. Unlike traditional lighting, lasers can synchronize perfectly with narrative from great distance. Whether used for concerts or theatrical performances, lasers communicate scale, precision, and emotion. In that sense, a powerful laser show isn't just visual. It's an experience, etching itself into memory. And the backdrop can be anything and anywhere. For example, a laser projection on the side of a building naturally captivates attention because it transforms any ordinary structure into a dynamic canvas. Seeing a laser presentation on a familiar space creates a sense of spectacle and surprise. It sparks curiosity and breaks the monotony of everyday surroundings, drawing people in with visual impact. And the best part is, these are no longer expensive, specialized devices requiring experts. Today, laser technology is so accessible that anyone can pick one up. With consumer-grade devices, you can set up and control them directly from your phone. What once required teams of skilled operators is now at the fingertips of everyday people. In short, something once exclusive is now in everyone's reach for low cost. As America edges towards a political nuclear meltdown on the increase, laser-driven visuals have become impossible to ignore. Their impact is undeniable. And now, Ontario looks set to witness the same attention-grabbing spectacle, but this time, exposing the dishonorable activities of lawyers. Small towns, big cities, let's face it, scandal sells. It spreads fast. It's whispered about, dissected, replayed, consumed, and on this occasion that appetite for scandal may finally deliver some good news for victims of lawyer malpractice. By far the biggest magnet for attention is the sex scandal. But where do those scandals most often originate?
Did you know that most affairs start at work? Roughly 85% of them, so let that sink in. 1 in 5 employees admit that they have been unfaithful with a colleague. Not at a bar, not on vacation, but at work. So what the hell is going on?
Let's just pause for a moment and imagine how devastating it would be for anyone, let alone lawyers, to have photographs or video footage of their unfaithful conduct suddenly blasted across public buildings for all to see. The public's appetite, of course, never seems to tire of a good sex scandal. The more embarrassing, the more humiliating, the more they revel in it. But behind every lurid headline, there's a fallout waiting, one that can dismantle lives and careers alike for those caught out. So how is this legal reckoning going to work? A long while back, because of his YouTube videos publicizing his own injustice, Edwards was approached by other activists focused on exposing lawyer misconduct here in Ontario, drawing on lessons from similar efforts in the United States. The strategy envisaged is to drive reform in an industry that has proven itself overly biased when addressing public complaints. The concern is the extent to which law societies in general will go to evade findings of dishonorable conduct within the ranks in order to preserve public confidence, promoting lawyers as pillars of integrity, even when consistency is absent, at the public's expense. In the face of this, whether the Ontario Law Society likes it or not all lawyer misconduct can be shielded, and that reality is about to break its long-held control over complaints and public perception of the profession. Creating maximum incentive for accountability, with no apparent avenue to have the legally defined misconduct of Roslynn Kogan and Pamela Miehls addressed, the cost now risks falling on other lawyers and their families, paying for the protection only afforded to higher-ranking corporate counsel. But should lawyers' private affairs be made public? When lawyers themselves expose and dismantle people's lives in family courts every day over such matters, they have already answered that question. And let's not forget the spouses being deceived. Surely they deserve to know the truth. So clearly a laser show would be absolutely devastating if exposing sexual misconduct. Indeed, what would a wife think if she found out she was having oral sex with her husband, only to find out he was having a gay affair? We don't have a crystal ball to truly gauge her reaction, but betrayal of this kind is rarely met with a sense of humor when it comes to being fucked around. And right about now, this revelation will have at least one lawyer going. But no, why make a fuss over conduct like this? Surely the husbands, wives, and partners of lawyers, those paragons of integrity, would simply endure such betrayal, swallowing the hypocrisy without a second thought. Right? It would be delusional to think otherwise. When it comes to betrayal, it is entirely reasonable to expect that many spouses will be deeply angered and will react accordingly. But the real question must be how best for injustice victims to proceed to achieve the greater impact. It sounds malicious, but let's not forget, a forced retribution response. This issue is having to treat fire with fire. So do you hold back on the laser show and just discreetly first give the evidence to the partner who is being fucked around? This could trigger an immediate response, with potentially dangerous and unpredictable consequences. Alternatively, a spouse may initially absorb the information, securing their own financial position before confronting the situation. Either way, for the unfaithful partner, there is always something to fear about a sneaky spouse. But where does the turning lawyers against each other come into it? Like the legal industry plays the long game to suppress and deter corruption allegations, that is to be the same playbook for the legal exposés. Once the disruption of the exposé has run its course, the adulterous lawyer will be informed that the personal cost borne by them and their family was never the true objective. It was simply a means of prompting their colleagues' misconduct to be professionally addressed in line with code. This reality will inevitably breed resentment, as lawyers risk having their lives destroyed to shoulder the fallout of misconduct that was never theirs. So what happens next? Does an embarrassed lawyer, faced with the collapse of their own family, choose to stay silent and instead take private revenge against the lawyer responsible for the damage? Or do lawyers simply seek to avoid scandal within their own practice, keeping everything buried? Either way, it's bad news for lawyers, but a powerful incentive for victims of injustice, as it creates a real urgency to confront legal misconduct without delay. And delay cannot be seen as the friend of adulterous lawyers because it risks them and their family becoming unnecessary collateral damage in the pursuit of getting authentic injustice addressed. Speed and independent oversight are clearly essential. But it remains to be seen how many legal careers the establishment is willing to sacrifice before the misconduct of Roslynn Kogan and Pamela Miehls is finally confronted to the satisfaction of law and legal code. For other victims of lawyer malpractice, this shifts the landscape entirely. No longer can injustice drift unresolved for years. It now demands swift, non-controversial action by authorities in strict accordance with established protocol, if only to contain the damage to third-party lawyers. With the public needing to do nothing more than place their injustice on public record through social media, websites, and other platforms. There will be no predicting which cases fall under the gaze of the overseers now poised to expose dishonorable members of the Ontario legal industry. As a result, it can only be interpreted as prudent. The system will need to rigorously treat all complaints most seriously. But is there a safety net to any of this? With countless affairs, some still unfolding, others long finished, but permanently documented, the wreckage doesn't vanish when the excitement fades. But can the exposés be stopped? The fact is, once the exposé cat is let out of the bag, it clearly can't be put back in again, so patently the solution is to try and avoid letting it out in the first place. But the foreseen problem to this is that the legal system thrives on the assumption that everything can be made adversarial, which is why the involvement of lawyers often escalates matters beyond what is necessary. The Edwards case proves the point. Adversarial distraction is no longer helpful. It is precisely what brought us here, and repeating it will not provide an ethical solution grounded in legal code. However, the emerging implications should now provide sufficient incentive for the Ontario legal industry to reassess how it addresses claims of legal injustice, focusing on solutions grounded in accountability, ethics, and the law. A cooperative approach that resolves conflict quickly rather than prolonging it. As per his conversation with investigators, it is Edwards' understanding that, if upon immediate submission all reasonable claims of injustice were rigorously addressed in accordance with the law and legal code, the exposés could be avoided altogether, thereby helping to establish a reliable culture of injustice investigation and accountability without more lives being wrecked in the process. In other words, the exposés are entirely avoidable. The system simply needs to act in good faith and implement a long overdue integrity protocol. At the end of the day, this is not a hate campaign by people driven by hostility. It is a long overdue response to an institutional failure to uphold its own legal standards. Given the system's entrenched resistance to public pressure, many believe it will take one or two exposés before it is forced, under protest, to yield to integrity, and no doubt to the internal outrage of affected lawyers, particularly when they realize the lifelong damage to their families was entirely avoidable. This is an observation that unfortunately has merit. Justice in Ontario has become a paradox, upheld in theory, yet routinely undermined in practice by those entrusted to uphold it. The result is that victims of injustice are not only harmed once, but re-traumatized through years of drawn-out legal procedures and maneuvers that amount to justice denied by outright obstruction. Yet obstruction of justice ceases to be treated as unlawful when it is carried out by those within the legal system itself. Rather than recoiling from the scrutiny this public initiative brings upon the legal industry, it should be recognized as a necessary opportunity, a catalyst to reform a system that has, for too long, normalized injustice. To conclude, in what should have been a straightforward malpractice case to resolve out of court, limiting harm to not one, but two Morneau Shepell clients, despite conclusive evidence, Shepell's lawyers declined the offer, and as a result it became a demonstration of what happens when Ontario's legal industry, en masse, abandons integrity and with it, its self-worth. Abusing privilege, Roslynn Kogan and Pamela Miehls' legal strategy turned into a campaign of unethical litigation. Disruption became their modus operandi, designed to overwhelm, distort, and do nothing more than evade accountability for Cathryn Heyman. As a result, Cathryn Heyman's unethical conduct wasn't just overlooked or ignored, it was actively protected and buried under more unethical misconduct by Morneau Shepell's own lawyers, who built their case on false representation amounting to false pretense, a false pretense completely irrelevant to Cathryn Heyman. And they still won. Given the lawyers prevailed, this outcome cannot by any reasonable measure be called justice. It instead lays bare a fundamental flaw in the system. When a system protects misconduct instead of confronting it, it stops being a justice system altogether, and this situation shouldn't be taken lightly. If law and professional codes are to mean anything, they make clear that conduct amounting to obstruction of justice is a criminal offense. In such circumstances, individuals, including Roslynn Kogan and Pamela Miehls, if convicted, could face penalties of up to 10 years imprisonment each. Lawyers, regardless of who they are, do not have impunity when breaking the law. To this end, if the law is truly upheld, accountability cannot be avoided. While only some of the issues are identified here through legal code, there can be no doubt that Kogan and Miehls cannot mitigate their position. When their training makes clear, they would have known they were committing misconduct. After years of deliberate obstruction to stall a remedy in line with law and legal code, Ontario's legal industry has engineered its own Kobayashi Maru, a no-win scenario of its own making. Yet the Law Society remains unable to act objectively, clinging to a contested position that now risks harm to other lawyers, and all to protect Kogan and Miehls. This is not oversight, it is a system structurally resistant to self-correction. It therefore raises a serious and unavoidable question, showing no regard for the dehumanizing destruction of his life. Has the resistance faced by Edwards from senior legal professionals and institutions alike all just been about shielding two corporate lawyers from the consequences of their illegal actions? If so, radical legal reform is now clearly a necessity here in Ontario. So, to those within the legal profession intent on protecting their interests, your mission, should you choose to accept it, is to insist that the Ontario Law Society stop contradicting its own legal code and the public statements of its lawyers, and instead, without professional favoritism, uphold its code at all times. One final point must be made. If any statement in this video is false or misleading, it should be formally challenged through proper legal proceedings to secure an immediate correction or retraction. Given the seriousness of the allegations presented, any further failure by legal authorities to act will be interpreted as evasion of both responsibility and liability. In this context, should the Law Society choose not to challenge the assertions made in this video, its further silence will reasonably be interpreted as an implicit concession, and a signal to courts beyond Brampton that breaches of legal standards by Roslynn Kogan and Pamela Miehls demand legal accountability. The Law Society is not free to ignore this injustice. Inaction is not a legal defense, nor can it stand as a lawful conclusion to a substantiated complaint. If, as the legal code makes clear, the conduct of Kogan and Miehls cannot be defended, then the Law Society of Ontario is bound by its mandate to uphold the code and hold them accountable. To this end, there is no lawful path to avoidance. There is now a clear imperative for the Ontario Law Society to put its house in order, not least because it is no longer possible for Kogan and Miehls to fully atone for their misconduct. Much of the human damage inflicted is irretrievable. That is precisely why it is imperative lawyer misconduct must be met with immediate accountability, without exception. For now, thank you for watching. This case demonstrates how far the Ontario legal industry will go to prioritize self-interest over public well-being, and this should stand as a clear warning to everyone who is considering civil litigation. Just because a lawyer wears a suit, it doesn't guarantee honorable conduct in practice, so prudence must dictate, until a complaint system is put in place that can ensure professional integrity. For self-preservation, we must remember the advice of our Prime Minister Mark Carney when he states,
When the rules no longer protect you, you must protect yourself.
Let's talk about that, because justice matters.